on behalf of Beyond Law CLC and Recruitment Associates, we welcome you all with Senior Advocate Ameet Deshpande, who all we know that his knowledge on different issues of law has always been well received. And today's topic, as and when we were talking with him, the common bottom line was coming that we should do something on Mitakshara. So ancestral properties as per the Mitakshara and the changes which have brought forth in the Hindu Succession Act is the topic which we will take today forward. And since, as we normally speak, once one person is from the Bangalore, etc., we asked the Vikram, who is a close friend of ours, though virtually we have met him so many times. I'll ask him to share his insights about Mr. Ameet and the topic for today. And then we'll request Mr. Ameet Deshpande to share his knowledge. Over to you, Vikram.
Thank you, Vikas sir. And it's a pleasure and it's an honor to speak about the learned senior advocate Ameet Kumar Deshpande sir. Sir is not apparently from Bangalore, as you mentioned. Sir is from Kalaburagi, and he is mainly practicing before the Kalaburagi Bench. And sir has vast knowledge on several facets of law. And yet again, it is an opportunity for us to hear sir on a particular aspect, more particularly from the academic perspective. Sir, on my personal behalf, as well as on behalf of Beyond Law CLC and Mr. Vikas Chatrat, I extend a very warm welcome to you, sir.
Thank you. Dhanyavad.
I also welcome all the other participants who have logged in on Zoom, as well as who are watching this live on YouTube. Over to you, sir. Over to you, sir.
Yes. Shall I start now?
Yeah.
Yes. So first of all, greetings and namaste to all. Thanks that you have taken out time to log in and have a discussion over this session. Before I would commence with the topic, I wanted to bring to the notice of all the people here that Mitakshara, a commentary on Yajnavalkya Smriti, is authored by Vijnaneshwar. His Lordship Justice M. Rama Joyce, who also was the governor of Bihar and Jharkhand, had found the inscriptions near a place in Karnataka, in the northern part of Karnataka, where just near 15 kilometers away from my hometown, Gulbarga or Kalaburagi, in a place named Martur, that this Vijnaneshwar, the author of Mitakshara, hailed and had actually authored Mitakshara from this place, Martur in Kalaburagi. A big, vast Vijnaneshwar Bhavan is built in Martur by the aid of His Lordship Justice M. Rama Joyce. All stalwarts of law have visited this place. I would request all of you who are interested in learning the original text of Mitakshara and learning the other principles related to Hindu law, kindly visit this place, see the overwhelming collection of books, the library maintained by Justice Rama Joyce and now taken forth by few people in trust. As you all know, for every civil lawyer, one of the most basic and fundamental requirements is to know the law of succession. Across all jurisdictions, across all jurisprudences, law of succession is always a matter of importance. Therefore, this session, I have taken it as an opportunity to evoke and create some interest among the students of law, young lawyers, and others interested in this, to have an in-depth insights and learning, an attempt to learn more the concepts of Hindu law. Of course, Mitakshara doesn't deal with only inheritance or devolution or succession of property among Hindus. It doesn't deal with only ancestral property. It deals with several chapters and several aspects, including one aspect of how a judge should be chosen, what should be his qualities. Several such aspects are found in the original text of Mitakshara. Anybody interested may actually have a look at that text to know how the pre-British Indian or Bharatiya jurisprudence was actually working well. Now, coming to the topic, when we are speaking of property, we all know property includes immovable property and movable property. Across all the other jurisdictions and jurisprudences in the world, property owned by a person is succeeded to by the heirs of that person only upon the death of that person. I haven't come across any other jurisprudence or jurisdiction in the world except the jurisprudence, except the Hindu jurisprudence, where right to property is available in a person from his birth and is not dependent only upon the death of another person. Therefore, this marks a very unique distinction between the principles of Hindu succession or inheritance and evolution and the principles of other jurisdictions and jurisprudences. We all know that the law recognizes the existence of what we reckon as the joint Hindu family. It is presumed that the normal condition of a Hindu is that he is in a joint Hindu family. However, this presumption doesn't carry with it the presumption that such joint Hindu family possesses joint Hindu family property also. It is required to be kept in your mind, this distinction between the two presumptions, one which is available and the other which is not available but has to be proved by sufficient evidence in the courts. Now, a joint Hindu family consists of all persons who are lineally descended from common ancestor and includes the wives and unmarried daughters wives of all the male persons. While we are thinking of a joint Hindu family, which consists of a broader number of persons, a narrower body in the Hindu joint family is a Hindu coparcenary. Hindu coparcenary, as classically understood, that is before the enactment of the Hindu Succession Act 1956, Hindu coparcenary consisted of all the male members of the joint family who are related to the present holder of the property up to the next 3 generations. In that way, if there is a person A, the propositus or the head of the family being male, his son, his grandson, and his great-grandsons altogether would have constituted a Hindu coparcenary within the Hindu joint family. This Hindu coparcenary is a creation of law. It is stated that it cannot be created by agreement of members. However, an exception is that when there is a partition in the family and there is a reunion after the partition, then that's an agreement by which the coparcenary is recreated probably. With this exception, the Hindu coparcenary is a separate family, is a separate legal entity, and is different from the joint family, Hindu joint family as such. As I had told earlier, as it is very unique to only Hindu jurisprudence, the members of this Hindu coparcenary acquire right and interest in the property of the joint family by birth. The sons, the grandsons, and the great-grandsons of the present holder of the joint family for the time being would all acquire an undivided and unascertained share in the joint coparcenary property held by the joint family. This was a concept which was known to the Bharatiya society, the Indian society. Mitakshara, one of the commentaries on Yajnavalkya Smriti, had described and enunciated several principles related to the inheritance and devolution and the characteristics of this coparcenary property and the coparcener's rights. This Mitakshara and its principles, with little variations through different commentaries of different authors, was applicable to the whole of the country, excepting the states of West Bengal and few parts of Assam, as is said somewhere, where probably another commentary named the Daya Bhaga was more applied. Mitakshara has been varied by few texts, say in the Konkan region or in the Bombay region. Otherwise, all the four schools of the Mitakshara Hindu law, the Bombay school, the Madras school, the Mithila school, the Banaras school, all the four schools have the common principles made applicable to the succession or the inheritance and devolution. Today, what is more important for us to understand is what are the basic characteristics of the coparcenary and the rights of the coparceners over the property. Now, before that, we need to understand that property can be held by a person as his self-acquisition, as his separate property, or it could be a property which has devolved upon him through his ancestors. What we can broadly call as ancestral property is the property held by a person which has come to him through his father, father's father, or father's father's father. Now, a property which has come to a person through any of his other relatives, though it would not be his self-acquired property, would also not constitute his ancestral property. So therefore, it is important to note that the property derived by a person from other relatives would not fall within the definition of ancestral property, whereas ancestral property would only mean that property which is derived upon him from his father, grandfather, or the great-grandfather. Now, if it's an ancestral property which has derived into the holder of the property, then as I told you earlier, he would not be the sole owner of the property, but he would have a share and interest in the property along with his sons, grandsons, and great-grandsons. So therefore, how would the other members of this coparcenary actually get their rights defined, the shares and the interests defined in this co-partnery property. What are the characteristics of this property vis-a-vis the members of the co-partnery? This is required to be understood with reference to certain principles enunciated in the text of Mitakshara, iterated, reiterated, emphasized and re-emphasized through several judgments of various high courts earlier, and the Honorable Supreme Court of India also. The incidents of co-partnery property is that all the members of the family, all the members of the co-partnery have a common ownership. They have unity of possession. Each member, though has only an unascertained share in the property, has commensality of ownership over the whole extent of the property along with the other co-partners. This is also very unique to the Mitakshara co-partnery property. And each member of the co-partnery has got an indefeasible right to claim partition during the lifetime of his parents, his father's father, or the great-grandfather. When he seeks for a partition or division of the co-partnery property, the Shastric Hindu law in the sense the classical Hindu law, or the Hindu law as was applicable prior to the enactment of Hindu Succession Act, or the earlier enactments which dealt with succession or inheritance to the property held by a Hindu. Mitakshara had stated, as also few other authors and commentators earlier had stated, that it is only in exceptional circumstances that a partition should happen in the family. Otherwise, the normal condition of the family should be joint. There were various reasons why it was said so. One was the protection of the whole of the members of the joint family, financially, socially, and on all other grounds. However, at least by way of an exception, a partition or division of the property was permissible under the Shastric Hindu law, the classical Hindu law. So there, a co-partner, whenever he seeks partition or division of his share in the property, would take unto himself, carved out, that share which he would be entitled to, dehorse the existence of the other living co-partners having their right and share in the property. When in the year 1956, the Hindu Succession Act was enacted, there were certain changes that were made to this classical text, the principles under the classic and the Shastric Hindu law. If we read through the debates of the Rajya Sabha of the year 1954 and 1955 as to what made the lawmakers to bring in Hindu Succession Act in the form in which it was enacted in the year 1956, was that amongst several other causes and reasons, one important factor that weighed in the minds of the lawmakers was that there was quite a bit of disparity between the rights of the female members of the Hindu joint family and the other members of the family. In order to confer equal rights on the female members of the Hindu joint family, the bill was proposed, and after certain debates, the then 1956 Act came to be enacted. Now, one important change that we can find is that, as was debated before in the Rajya Sabha, pursuant to the Joint Select Committee's discussion, one of the ideas was to do away with this joint family concept so that there can be an equal succession, a common principle for succession of the property among the members of the Hindu family. However, a contrary debate was made saying that such step would be not so congenial for the existing situation then. And therefore, what was ultimately coined in was Section 6 of the Hindu Succession Act, as it was prior to the Amendment 2005. Now, this Section 6 actually stated that the concept of survivorship, as was available prior to the 1956 enactment among the co-partners, would still continue to be effective. However, with one change, in the existence of any female member left behind by the deceased co-partner, the female co-partners would, the female members of the female heirs of the deceased co-partner would succeed to the share that the deceased co-partner would have had in the co-partnery property. Otherwise, prior to the 1937 Act, prior to the Hindu Women's Right to Property Act 1937, if one co-partner in the co-partnery dies, his right would survive upon the other surviving co-partners. Let us say that there are 4 brothers, A, B, C, and D, who constitute the co-partnery along with other male members of the family. And if A dies, then the interest in the property that A had would not be succeeded by his lineal descendants, but would survive upon his brothers B, C, and D. That was the principle prior to the 1937 enactment, prior to the 1956 enactment. The 1937 enactment made a small change where the few female members related to the deceased co-partner were given certain right in the property so far as the interest of that deceased co-partner is concerned. Now, in the year 1956, they retained that principle initially, stating that the female co-partners would also get their right to succeed to the interest that is left behind by the deceased co-partner. And if the deceased co-partner has not left behind any female heirs, then the classical principle of survivorship would continue to be effective on such property. Subsequently, however, as everyone of you know, by the amending Act number 39 of 2005, the Hindu Succession Act 1956 is amended. Right conferred on a son as a co-partner is now also conferred equally on the daughter of the family, daughter of the co-partner. So from the Amendment Act 2005, the daughter is also now equally a co-partner, and therefore the definition of co-partnery, as I had told you earlier, will have to be also understood in the context of this change, that now it would not only include the male members of the joint family, but also the daughters of the co-partners who would be included within the definition of co-partners. However, the daughter is entitled to all the rights like a son in the co-partnery property and is also amenable to all the liabilities that the son has. One important aspect we need to know is that when the property is inherited or succeeded by the children of the deceased co-partner, the person who is succeeding to this property would also retain that property as his ancestral property, qua his children, his grandchildren, and his great-grandchildren. This is how the Shastric Hindu law would explain the nature of the property held by each person in the coparcenary after the earlier coparcener of the earlier generation passes away. However, a change is brought in under the Hindu Succession Act 1956, where the principle of survivorship of the right of the deceased coparcener on the other surviving coparceners is retained when the deceased coparcener does not leave behind any female heir. But if he leaves behind any female heirs, then a notional partition is required to be made just before the death of the deceased coparcener to carve out what would be his share in the coparcenary property, and whatever is his interest in the coparcenary property will be then succeeded to by the heirs enumerated in the schedule to the Hindu Succession Act, applying section 8 of the Hindu Succession Act. Have a very serious look at this. There is an ancestral property consisting of the coparceners. One coparcener passes away, leaving behind female heirs and other lineal descendants. The female heir would get the right to succeed to the interest of that deceased coparcener under section 8. And now, if she is the daughter, after the 2005 amendment, she would also be entitled to a share as a coparcener along with the sons of the deceased coparcener. The difficulty arises when it is to be decided as to what would be the nature of the property that the person who has succeeded to the deceased coparcener under section 8 of the Act. I would be referring to one decision of the Honorable Supreme Court in the case of C.N. Arunachala Mudaliar versus C.A. Muruganatha Mudaliar, which is reported in AIR 1953, Supreme Court, page 495. Someone can actually type this so that others can note it. I'm very sure that everybody might be knowing this decision. However, for the purpose of learning, we need to note it. AIR 1953, Supreme Court, page 495. One important aspect was discussed in this decision as to the right of the father governed by the Mitakshara law to dispose of immovable property to a stranger without the concurrence of his sons, and his right to give away the property under a will or a gift. While discussing this, one of the principles that was noted by the Honorable Supreme Court, where the decision is rendered by a bench of 3 honorable judges of the Supreme Court, is that when the property, as is classically understood, is derived from the father's father, or the father's father's father, would be an ancestral property in the hands of the person who has derived it. Then, from that understanding of the definition of ancestral property, it was held that the property which a person derives from his father, father's father, or father's father's father would be held by such a person as ancestral property only, even if it is by way of a will or a gift, provided certain circumstances are proved or certain circumstances are existing. That is, the will or the gift is made by the person who held this property with an intention to confer that right upon the son. Now, this decision in paragraph 10 of the judgment, if I should read, says this: the controversy arises on the question as to what kind of interest a son would take in the self-acquired property of his father, which he receives by way of gift or testamentary bequest from him, vis-a-vis his own male issues. Does it remain self-acquired property in his hands also, untrammeled by the rights of his sons and grandsons, or does it become ancestral property in his hands, though not obtained by descent, in which his male issues become co-owner with him? And then, referring to various decisions, the Honorable Supreme Court in this case has answered the issue. Now, this is a decision decided prior to the enactment of the Hindu Succession Act 1956. So this defines what was the understanding of the Shastric principle, the principles under the Shastric Hindu law. If we now go to read a decision in the case of Commissioner of Wealth Tax versus Chandar Sen and many other decisions thereafter, especially a decision in the case of Uttam versus Saubhag Singh and others, reported in AIR 2016, Supreme Court 1169. The Supreme Court here, after referring to the decisions of Commissioner of Wealth Tax Kanpur and others versus Chandar Sen, reported in AIR 1986, Supreme Court, page 1753, and few other decisions, holds that a person who has succeeded to the property of his father, who was a co-partner in the property, would succeed under Section 8 of the Hindu Succession Act. When he succeeds under Section 8 of the Hindu Succession Act, after a notional partition is made under Section 6 of the Hindu Succession Act, then because of this enactment and its clear intendment, it cannot be assumed that the person succeeding would hold this property for his children and grandchildren or great-grandchildren or any other heirs, because the person succeeding is succeeding under Section 8 with reference to the Schedule 2, the Hindu Succession Act 1956, and the said schedule only refers to those persons who will succeed. By implication, the absence of any other heir in the said schedule, the Parliament has intended to exclude such a person from succeeding. If the Parliament has intended to exclude such a person who is not enumerated in the schedule, in the class 1 and class 2 of the heirs, then by this principle under the Shastric Hindu law, it cannot be extended, and such persons who are excluded expressly cannot now be given the same right again. So by this principle, it is held that no other person would get an interest in the person, in the property which has been succeeded to by the said person. One of the reasons is also that Section 4 of the Hindu Succession Act 1956 says that any other interpretation or any other principle contrary to this enactment, the enactment prevails and not the earlier interpretation of law would continue to be effective. Therefore, this decision, which refers to Commission of Wealth Tax versus Chandra Sen, which refers to Yudhishthir versus Ashok Kumar. Yudhishthir versus Ashok Kumar reported in AIR 1987, Supreme Court, page 558. Then Bhavar Singh versus Puran, reported in AIR 2008, Supreme Court 1490, which all decisions basically follow the principle laid down in the case of Chandra Sen. Would be stating that there is a complete deviation from the understanding of the concept of co-partnership rights and the rights of the co-partners who have succeeded to the property held by a deceased co-partner. Now, with this, probably, as I understand, there will be a little difficulty in continuing the joint family itself, which was one of the reasons for the enactment of 1956 Act. I request all of you to read the Rajya Sabha debates, where one of the members of the in the debate had stated that the purpose is to do away with this joint family system for the reason that the difficulties in succession and the anomalies in succession or inequalities in succession should be curtailed. However, after this 2016 decision, in the case of Uttam versus Saubhag Singh, I have come across another decision of the Honorable Supreme Court, rendered by by the judges of equal strength, by a bench of equal strength, in the case of Arshnur Singh versus Harpal Kaur. This is reported in 2020, volume 14, SCC, page 436. In this decision, the Honorable Supreme Court takes note of few other decisions of the earlier era, and then holds that, after referring to Uttam versus Saubhag Singh, also holds that if there is a son born to a co-partner who has succeeded to a co-partnership property, then so far as that succeeding co-partner is concerned, he would begin a fresh talk of his family, and therefore in the facts of this case, distinguishing the facts of the case of Uttam versus Saubhag Singh, the court holds that this would still be an ancestral property. Now, this makes a very interesting reading for a lawyer. And therefore, I request all of you to have a look at the decision in the case of Uttam versus Saubhag Singh, and also thoroughly read the facts of that case, and thereafter to read the facts of the case of Arshnur Singh versus Harpal Kaur, and understand how the Honorable Supreme Court has laid down the principles. The citation of Arshnur Singh versus Harpal Kaur is 2020, volume 14, SCC, page 436. One other decision of the month of November 2019 now takes us back to the principle laid down in Commissioner of Wealth Tax versus Chandra Sen, and holds that since the schedule enumerating class 1 and class 2 heirs to the Hindu Succession Act excludes few heirs, the law has to be understood that the co-partner succeeding to the property held by another a deceased co-partner would hold it under Section 8 and would not hold it for and on behalf of the children or the grandchildren or other members who would also come within the definition of co-partners with him. This decision is in the case of Radha Bai versus Ram Narayan, rendered on 22nd of November 2019 by a bench of 2 honorable judges of the Honorable Supreme Court in civil appeal number 5889 of 2009. Another decision is in the case of M. Arumugam versus Ammani Ammal and others in civil appeal number 8642 of 2009, rendered on 8th of January 2020 by a bench of the equal strength of 2 honorable judges, where again the principle in the case of Commissioner of Wealth Tax versus Chandra Sen has been followed and reiterated. I would request all of you to read these judgments also. I may remind all of you here that in these kind of sessions, though it's only one person who is talking and trying to emphasize what are the principles of law, this is essentially a session to evoke some interest amongst all the scholars here to have more research, to do more research. So what I would be stating is not to be taken as a lecture, but is to be taken as information so that all of you can now proceed further to make more deeper research on the issue. So what I would like you all to understand is another important factor. Now let us come to, all of you are aware, a decision of the Honorable Supreme Court in the case of Vinita Sharma versus Rakesh Sharma. Now I had read to you the judgment in the case of C.N. Arunachala Mudliar, the principle laid down therein, then the principle laid down in Commissioner of Wealth Tax versus Chandra Sen, reiterated in Uttam versus Saubhag Singh, reiterated in 2 other subsequent decisions. Now this Vinita Sharma versus Rakesh Sharma has overruled the decision in the case of Prakash versus Pulvati and partly overruled the decision in another case, and has held that the amendment made to Section 6 of the Hindu Succession Act, where the daughter is now made a co-partner along with the son and is given certain rights and liabilities, such amendment is retroactively applicable, and few other principles are laid down therein. However, I want to emphasize something different. Kindly read paragraph 28 of the decision, where the Supreme Court now holds that in case co-partnery property comes to the hands of a single person temporarily, it would be treated as his separate property. But as soon as the son is born, the co-partnery would be revived in terms of the Mitakshara law. The Supreme Court, this is a bench of 3 judges, refers to 2 or 3 earlier decisions. It refers to the case of Sheila Devi versus Lalchand, reported in 2006, volume 8, SCC, page 581, which in turn has referred to M. Yogendra and others versus Leelamma and others. And another decision is referred to in the case of Sita Bai versus Ramchandra, reported in AIR 1970, Supreme Court, page 343. Then referring to the principle of law laid down in the case of State Bank of India versus Ghamandi Ram, reported in AIR 1969, Supreme Court, page 1330. Kindly note this, AIR 1969, Supreme Court, page 1330, which is a a judgment which has clarified all the characteristics of the coparcenary property, and it's a good learning even to just read this one judgment. Now, in paragraph 28 of the decision in the case of Vinita Sharma versus Rakesh Sharma, and thereafter, referring to all these decisions, the Supreme Court holds that yes, it is true that the sole coparcener would be holding that property for himself. However, if there is another son born to him, then the coparcenary would revive as per the Mitakshara law. Here, I would leave it to the audience here, the scholarly audience here, to now make more research into this and to see if there is any anomaly in the principles of law laid down emanating from two sets of decisions. Right from C.N. Arunachal Mudaliar to Uttam versus Saubhag Singh to Vinita Sharma. Is there any anomaly in the principles of law laid down? If there is any anomaly, which of it would be appropriate, justified in the given text of the Act and under the principles of the Shastric Hindu law? And what should be the interpretation, if at all it is required, to be given in the context of the enactment, so that such scholarly research made by the community of lawyers would be assisting the courts to arrive at proper decisions in future also, based upon such research, if necessary. Therefore, my endeavor is neither to tell you how much I have read it, nor to exhibit how ill-read I am, but to only, as I told you earlier, to make you all feel that yes, this is an area into which you all need to make more deeper research, and whenever the occasion arises, to place it before the court in your arguments in appropriate cases, so that there will be better enunciation, deeper enunciation of the law. With this, I would request Mr. Vikas and Trivikram to permit me to conclude here. I would once again remind all of you to kindly visit the place Martur in Kalaburagi or Gulbarga, the northern part of the state of Karnataka, where Vijnaneshwara has authored this text Mitakshara. And even today, after enactment of the 1956 Act also, still we are unable to do away with Mitakshara. Mitakshara has still its own effect, is still being useful in deciding cases. Therefore, you all please come here once. Thank you, sir. Thank you, madams, all the elite group of scholarly people here. Thanks a lot for bearing me for this much of time.
Mr. Ameet, it was not that one was bearing with you. It is in fact a knowledge sharing. And knowledge sharing is always enlightenment of the mind as well as of the soul. This is Rajiv Talwar. He says, what happens if a man had two marriages? One is annulled and second is working. Can the earlier wife also become a successor?
One is
married.
Yeah.
Two marriages, one is annulled and second is working. Means second
yes.
is actually this thing.
The annulment of the marriage has its own effect under the Hindu Marriage Act, and therefore
he's asking whether the earlier wife would be a successor.
No.
This is now from
the earlier wife. See, in this case, the succession opens upon the death of the person who holds the property. As on the date of the death of that person, whichever marriage subsists, that person would become the widow, who would be succeeding under Class 1 of the Hindu Succession Act, the Schedule to Hindu Succession Act. Therefore, there is no question of the person whose marriage has been annulled, the widow or the wife or the female, I can even call, she cannot even be called as widow, the female whose marriage has been annulled before the death of the person.
It is the way it says, if a partition occurred prior to 2005, in which daughter was not given any right, after the amendment of 2005, will the daughter or her heirs get share in the joint property?
Yes, sir. Vinita Sharma versus Rakesh Sharma is the decision which holds the field now, which says that if there is an oral partition prior to 2005, then the daughter would still have a right to claim share in the property. The exception is with regard to a registered partition happening prior to 2005, or an oral partition which is evidenced by public records in an exceptional case. So if it is a registered partition, the daughter loses her right, which is registered partition prior to 2005. If it is an oral partition which is not evidenced by any public record, the daughter would be entitled to a share to reopen that whatever earlier partition had happened and to claim her right as a co-partner along with the other sons.
This is Dr. Mohan R. Bhola writes that it's a great and a vivid presentation. We thank you to Dr. Mohan, who is following regularly. We will share the judgments on the group. We will ask Mr. Ameet to share the total list. We will share it on the WhatsApp group. Then Mitesh CA asked, property granted from government, whether it is a joint or a self-acquired property of the father.
It is a separate property of the father. You can also refer to the commentary on Hindu law by Mullah, where it is defined as to what are separate properties. There are some 9 properties which are enumerated in that commentary, which are stated to be separate properties. And all that probably is based upon some or the other decision of one or the other high courts in the country. And therefore, for the present, we can say that such property would be his separate property.
Chandrasekhar Rao, the Vinita Sharma civil appeal number is 32601 of 2018. And date of decision is
August 2020.
Yeah. And that is written by Justice Arun Mishra. And I will ask Mr. Trivikram to share his insights. Trivikram?
Yes, thank you, sir, for a scholarly presentation. In fact, one of the questions I think that would be valid, one asked in the box here is there any time limit for the daughter to move the court or claim her father's property from the date of her father's death?
Sir, there is no time limit for filing a suit for partition, because the cause of action to file a suit for partition would be a denial to give her the valid right, and till that point of time should continue to remain joint with the others. So therefore, there is no limitation as such for that. Few exceptions are where there is an alienation known to you, and if you want to set aside an alienation, then there are few articles, but otherwise there is no such limitation for asking a share by filing a suit for partition by the daughter.
And one question by Mr. Rajiv, though it is slightly digressed from the main topic, I would just read it out, sir. Sir, in a will, is it mandatory to state the reason why it is alienated to a particular person or son?
The courts, if we go through the principles of law laid down by the courts, it is not necessary that it should be clearly stated in the will why he is disposing of the will and bequeathing the property in favor of one person to the exclusion of others. However, what we call as suspicious circumstance is what the court would be looking up to see whether the will is valid or not. This will should not be shrouded with suspicious circumstances. Otherwise, it is not mandatory for anybody to write the reason why he is excluding someone and is conferring the benefit on only one or two.
This is in a suit for a partition filed by the grandson during the lifetime of the father is maintainable under the Hindu Shastric law.
Yes, sir, absolutely. It is maintainable. He is a co-partner along with his father and his grandfather, and therefore, being a co-partner, he has his own right to carve out during the lifetime of his father and his grandfather whatever interest he has in the co-partnery property.
Sanjita says if the ex inherits the 50% property of his grandfather directly in the first case and rest 50% after the death of the person. With regard to the question is not very clear. Is the probate declaration of must to change the khata on the basis of a will?
Sir, so far as I have understood it, there cannot be a change of khata based upon a disputed will, and therefore one has to seek declaration of one's right to the property to claim a change in the khata in the revenue records based upon a will, because the revenue authorities have no jurisdiction to look into the veracity, the correctness, or otherwise of the will. However, I think that's not the topic which we are discussing today.
That shows that we will have to discuss exclusively on will. There are a lot of confusions and questions pertaining to will. Perhaps that could be our next topic of discussion.
Yes.
I think we lost Mr. Vikas for a moment. I think he would be relogging in, sir. We'll just wait for him before we wind up.
Sir, one question posed in the chat box, which I could read in a small time,
Yes,
is
sir.
if an unmarried son or daughter, how would his assets be succeed? Who succeeds to his assets? Kindly refer to the Schedule 2, the 1956 Act, which describes the heirs who would succeed to. There are Class 1 and Class 2 heirs, and according to the entries therein, whoever is available would succeed.
Just wait for a few more seconds before we wind up. I want Mr. Vikas also to be present. We have lost him because of network issue, I understand.
Mr. Hitesh has asked a question. The question depends, the answer to this question depends on several facts. If there was a partition earlier in the 1974 upon through a registered document, or which is evidenced by public records now, then the daughter or the heirs of that daughter will not be in a position to ask for the share. Otherwise, it would not matter whether that partition, which is not what accepted under Section 6 of the Amendment Act 2005, if it is an unregistered partition or a oral partition which is not evidenced by public records, then the daughter has got a right to claim partition in the property. That is what exactly Vinita Sharma versus Rakesh Sharma judgment deals with. The principles of law and the conclusions therein show this. One other question is what happens to the female who gets the property under Section 6, whether her children, sons and daughters would have a right or not. Obviously, her children, the daughters and sons will have a right in the property of that female who gets the property under Section 6(1) also. The children of that female become the Class 1 heirs again, so they will be entitled to that property.
Mr. Shashikumar has asked this question, but yes, I'll just read it out, sir. Father had put partition case, later it was closed after his death as abated. Can his children of deceased apply for fresh partition case after 6 years?
Yes, sir, it can be applied for, because suit being abated would not take away the right of any person, and the children have their own right to claim the share in the property, or their right or interest in the property, and therefore they can file a suit again, or they can revive the earlier suit by requesting the court to condone the delay. So with few exceptions, it is permissible.
I think more or less we have touched all the questions, sir.
I am
One
not aware
case-
whether I was competent to answer any of these questions. I have made my
Certainly,
attempt.
without any doubt, sir, without any doubt, we have clarified and we have given utmost clarity to the topic discussed. And you were kind enough to answer other questions which were not actually connected to the main topic of discussion. So we have to be more grateful to you for that. So I think I'm not able to see Mr. Vikas, sir. However, I think it's time up. So once again, on my personal behalf and behalf of Beyond Law CLC, many thanks to you for the scholarly presentation, enlightening us on particular aspect of law. Sir. Thank you so much.
Thanks a lot. Thanks, everyone.